a person holding a phone with an image of lips over their own lips and then holding a finger over that image as if hushing someone. Figure 5.1, Credit, Modification of Work Hush, by Pixel Addict /Flickr. Com, CC by 20. Chapter Outline. 5.1 Trade Secret Protection. 5.2 The Foundations of Trade Secrets Law. 5.3 Elements of a Trade Secret. 5.4 The Secrecy Requirement. 5.5 Misappropriation of Trade Secrets. 5.6 Remedies available for the misappropriation of trade secrets. Learning objectives. After completing this section, you will be able to identify the roots of trade secret law in the United States. Explain the purpose of the Uniform Trade Secrets Act. Unlike patents and copyrights that are issued in accordance with federal law, trade secret protection until very recently emanated from state law. But on May 11, 2016, the Federal Defend Trade Secrets Act, DTSA, was signed into law, thereby creating a federal cause of action for trade secret misappropriation that largely mirrors the current state of the law under the Uniform Trade Secrets Act, UTSA, which has been adopted by 48 states. Trade secret law in the United States is largely rooted in the English legal tradition and was first incorporated through the court-made common law. The general consensus is that trade secret law originated in England in the early 1800s. Roman III early cases dealt with trade secret concepts, not in modern trade secret vernacular, but instead through the guise of jurisdictional or restraint of trade terms. The trade secret concept began in American jurisprudence in the case of Vickery v. Welch, 36 Mass. 523, 1837. The Massachusetts Supreme Court first expounded on trade secret law in modern terms in Peabody v. Norfolk, 98 Mass. 452, 1868. In the 145 years since the Peabody decision, the courts, including numerous federal courts, have addressed trade secret issues and have contributed to the current body of trade secret law. However, because each state may regulate trade secret law independently, each state has developed its own legal regime, involving a mixture of both statutes and common law, to regulate and protect trade secrets. Uniform Trade Secrets Act. In an effort to harmonize and standardize trade secret law in the United States, the Uniform Law Commission published the Uniform Trade Secrets Act, UTSA, in 1979. The UTSA sought to create a uniform trade secret law regime from state to state. However, the UTSA itself was not binding upon states at publication. In order for the UTSA to be successful, the states themselves needed to adopt and enact the Model UTSA statute created by the Commission. In 1980, Minnesota became the first state to adopt the UTSA. Since 1980, most states have adopted the UTSA, many with the 1985 amendments to the Act. New York and Massachusetts remain the last states that have yet to adopt the UTSA. Although the UTSA harmonized various state law approaches to trade secrets, each state enacts the UTSA with any modifications or customizations the state legislature desires to make. Thus, although most states have adopted the UTSA, each state may have a slightly different adaptation of the UTSA. One important provision of the UTSA is Section 7, which deals with the interaction of the UTSA and state law. Section 7 preempts certain state law causes of action. Section 7 displaces conflicting tort, restitutionary, and other law-providing civil remedies for misappropriation of a trade secret. Trade secret misappropriation. Although this section seems to indicate that the UTSA broadly replaces all state laws dealing with misappropriation of trade secrets, there is debate as to what constitutes conflicting tort, restitutionary, and other law. Additionally, what it means for a common law remedy to be based on misappropriation of a trade secret is often contested. Owners seeking to recover damages for misappropriation generally argue that only common law causes of action that have elements identical to the UTSA are preempted, while defendants argue that any cause of action used to protect trade secrets is preempted because it is duplicative of the UTSA. Despite this potential conflict between the UTSA and state common law, this chapter focuses on the main body of trade secret law as governed by the UTSA. Learning objectives. After completing this section, you will be able to identify the key criteria used to qualify as a trade secret. Explain how ideas can be protected as trade secrets. To qualify as a trade secret, the information in question must meet two essential criteria. First, the information must attain its value from the fact that it is not generally known. Second, the owner of that information must take reasonable efforts to maintain its secrecy. Absent these two elements, information does not qualify as a trade secret and is not entitled to trade secret protections that prevent or remedy misappropriation under the UTSA. Trade secrets are not limited to particular subject matters, although the knowledge or information to be protected need not take any particular form. A trade secret can be information or knowledge in the form of a formula, pattern, compilation, program, device, method, technique, or process. Although the UTSA defines what may be a trade secret, various courts interpreting the UTSA have come to different conclusions on what type of material should be considered a trade secret. For example, whereas courts have found that an insurer's database is a trade secret under Wisconsin law, a similar database was found not to be a trade secret in Rhode Island. Roman 6. The value of secrets. For information or knowledge in any of the above forms to be considered a trade secret, it must derive independent economic value because it is not generally known to, nor readily ascertainable by, other persons who can profit from its disclosure or use. Some examples of information courts have found to be trade secrets include computer software, sales information, customer information, and manufacturing formulas. However, merely because information is not known to the public does not necessarily make the information a trade secret. For example, information that is not generally known by the public, but is known by different manufacturers in the same industry, likely does not qualify as a trade secret. Roman 7. Material that is ascertainable through public sources generally does not derive independent economic value, justifying trade secret protection. If the information in question cannot be quickly or easily ascertained from examining or testing the publicly available product, then it is more likely to be a trade secret. Roman 8. Conversely, if the information may be discovered through public observation of the product or the company's displays, it is unlikely to be a trade secret. Roman 9, for example, customer lists are not considered trade secrets when the identity of the customers could potentially be discovered through public sources. However, identical information, if not available through public sources, could constitute a trade secret. Additionally, processes or systems that are simply a compilation of known information generally do not rise to the level of trade secrets. The courts, however, are still quite divided on this issue. A pencil lays on a spreadsheet. Figure 5.3, credit, modification of work by Niall Bradshaw via Flickr/CC by 2. 0. Protecting ideas as trade secrets. In addition to information, certain ideas may constitute trade secrets. Although ideas were not protected as trade secrets under common law, the UTSA provides protection for certain novel and concrete ideas. For example, remedies for misappropriation of an idea may be permitted based on the existence of a confidential relationship. The elements that must be proven under this common theory are 1. A novel or original idea. 2. Reduced to concrete form. 3. Disclosed to the defendant in a confidential relationship, i.e., one in which it would be implied that use would not be made without compensation. And 4. Used by the defendant. Protection of an idea may also be permitted on the basis of a contractual relationship with the defendant. Parties may enter into a contract to protect an idea being submitted or disclosed to another person or company. The major benefit of a contract to the submitter of an idea is evidence of a protected disclosure that is deserving of trade secret protections. The major benefit of a contract to the recipient of an idea is the establishment of the ground rules under which compensation, if any, will be payable to the submitter. Corporations that receive unsolicited ideas many times grapple with how to best protect use of those unsolicited ideas. To protect themselves from the uncertainties of trade secrets law, the idea must be converted from an unsolicited idea to a solicited idea. This may be accomplished by contacting the submitter and alerting them that the idea will be considered only with the understanding that the use of the idea and decisions regarding compensation for that idea rest solely with the corporation. Whether the trade secret takes the form of information or an idea, the owner of that trade secret must show not only that the trade secret was not generally known or readily ascertainable, but also that the lack of general knowledge of the trade secret conferred some value to the owner. When the owner derives a profit from licensing the use of the protected information, the value to the owner is quite apparent. However, in cases where the owner is seeking to show he was injured in the marketplace, or through the loss of profits after costly research and development, the value may only become apparent by inference. But even if information is not generally known and gives the owner some value, the information is not a trade secret unless the owner takes steps to protect the secrecy of the information. A combination lock on a vault door. Figure 5.4, credit. Rob Pongsajapan via Flickr/cc by 20. Learning objectives. After completing this section, you will be able to explain the steps that businesses can take in order to protect trade secrets. Describe how trade secrets can be accessed through passive and active disclosure. The second element necessary to gain trade secret protection is evidence that the trade secret's owner made a reasonable effort to maintain secrecy. This flexible standard set out by the UTSA is often a point of contention, which results in litigation. To determine whether a piece of information rises to the level of a trade secret, courts often engage in a highly factual inquiry into the security measures taken by the owner to protect a trade secret. For as the Supreme Court has noted, if an owner has not taken steps to protect the trade secret, their proprietary interests may be diminished. Under company lock and key, because the UTSA may be varied by any state, the level of secrecy required varies from state to state. For example, a version of the UTSA adopted by some states contains a provision that reduces the burden of secrecy placed on the owner of a trade secret. Specifically, this version of the UTSA provides that the existence of a trade secret is not negated merely because an employee or other person has acquired the trade secret without express or specific notice that it is a trade secret if, under all the circumstances, the employee or other person knows or has reason to know that the owner intends or expects the secrecy of the type of information comprising the trade secret to be maintained. Although this provision tips the scales in favor of trade secret protection, it should not be viewed as removing the affirmative obligation the UTSA places on one seeking protection of trade secrets. In both states that have and have not modified the UTSA in this manner, the measures taken to secure the information are key to finding whether the information will be protected as a trade secret. Because trade secret protection is only given to information that is subject to reasonable efforts to maintain secrecy, every person or company that desires to protect its trade secrets under the UTSA should adopt and implement a trade secret protection plan. The specific elements of such a plan will vary depending on the nature of the intellectual property to be protected, as well as the circumstances surrounding its development and use. However, in taking reasonable efforts to protect the secrecy of the information, many different factors are considered. Because no rigid formula exists to determine if reasonable efforts to maintain secrecy are in place, courts look to many of the best practices, discussed below, to determine whether an owner of information made reasonable efforts to protect its secrecy. Protection plans, memorializing a trade secret protection plan in writing, helps to ensure that the business or person is indeed taking reasonable measures to protect the trade secret. The person or company seeking to protect its intellectual property through the use of trade secret law should maintain a written statement of its trade secret security policy. This statement can be written in the form of a policy manual and helps prevent situations in which unwritten rules are followed or rules are enforced in a lax manner and then eventually ignored. Moreover, should litigation become necessary, it is easier to persuade a court that the security procedures were indeed a primary concern if they are enumerated in writing. However, if security measures are merely written but not followed, it may be difficult to prove reasonable efforts to maintain secrecy. Roman 12. A trade secret protection plan should include a program for ensuring that employees are made aware of the trade secret status of information and that the employees are periodically reminded of their confidentiality obligations. Discussions between the employer and the employee may be appropriate. Writing an annual conflict of interest letter to remind management-level employees of their responsibilities in keeping information confidential may also suffice. An essential part of this program is making cert that employees are aware of and familiar with the written trade secret protection plan discussed above. Employees should also be required to sign confidentiality agreements acknowledging that they have access to trade secret information, that they will not disclose or misappropriate that information, and that they will report all disclosures. Finally, exit interviews should be conducted for employees leaving the company. This interview provides an opportunity to remind employees of their written obligation not to disclose or misuse any trade secret information, and to extend an open door to discuss any issues or concerns that may arise in connection with their future employment. Roman 13. In addition to educating employees, reasonable efforts to protect information often include physically restricting access to trade secrets. Trade secret information should be treated differently from non-proprietary information and should, if possible, be physically segregated so that it is not readily accessible. For example, it is not uncommon to restrict visitor access to sales and administrative headquarters. In addition, access to the intellectual property should be restricted to those with a need to know or access the information. Depending on the nature of the intellectual property to be protected, reasonably restricting access to trade secrets may be as simple as segregating the information in separate file drawers, or may require measures as extreme as designating an entirely separate facility to house the intellectual property. Roman 14. If possible under the circumstances, physical security measures should be instituted, including the use of locks on doors, gates, and cabinets containing trade secrets. These physical security steps should be obvious to both employees and third parties who may have occasion to visit the area in which trade secrets are stored. Roman 15. These types of security measures communicate that an effort is being made to protect the information. Strategies for protecting trade secrets. Given the ease with which documents can be reproduced, trade secrets that are reduced to writing should be treated with special care. Documents containing trade secrets should be clearly labeled with shorthand instructions that are consistent with the written trade secret protection plan. For example, documents may be marked secret or confidential. Roman 16. Access to these documents should be monitored, and all persons allowed access to the documents should be informed of the meaning of the trade secret designation on the document and the relevant provisions of the written trade secret protection plan. This attention to detail should also be followed in arranging for proper destruction of the documents. Roman 17. Like trade secrets that are reduced to writing, trade secrets stored on a computer system are particularly susceptible to theft. Access to a computer system containing trade secrets should be restricted in accordance with the written trade secret protection plan, and all physical computer-related items, such as disks and printouts, should contain the same trade secret legend used to identify documents containing intellectual property. When allowing third parties, be they members of the public or business associates, access to a facility in which trade secrets are stored or used, care must be taken to ensure that trade secrets are not inadvertently disclosed. Disclosure can occur either passively or actively. Passive disclosure might occur by carelessly leaving documents containing trade secrets in open view when business associates from another company visit your facility. Active disclosure might occur during a guided tour of the facility when a tour guide reveals the nature of a project or process the company is working on or has recently perfected. Roman 18. The type of active trade secret disclosure that can occur outside of the facility where trade secrets are housed is through the dissemination of confidential information at trade shows, in magazine articles, in publications, in press releases, or during public speeches. Such disclosures often occur unwittingly because they are made by marketing executives or mid-level managers who are not themselves instrumental in the development of the trade secret, and who are often charged with a goal somewhat at odds with maintaining the secrecy of intellectual property. That is, their duty often is to publicly disclose the company's achievements. Similar difficulties might arise when engineers or those responsible for the creation of trade secrets exchange ideas with their colleagues from other companies at professional seminars. Roman 19, one method of curtailing such disclosures is to insist that all publications, articles, and speeches be reviewed and approved by a filter committee prior to dissemination. Roman 20. Although the very nature of many businesses requires that a company disclose its trade secrets to prospective buyers, licensees, joint venturers, or other outsiders, this does not mean that a company must surrender all rights to its trade secrets. Rather, when the company enters into a transaction with a third party, it should cautiously monitor the flow of information to the third party and document the nature of the trade secrets exposed and the specific limited use to which they may be put. Roman 21, you might consider putting outsiders on notice regarding the need to keep information confidential and even require the signing of confidentiality agreements. The standard of what constitutes reasonable efforts to maintain secrecy varies substantially depending upon the circumstances and the information that is being protected. However, the different methods of maintaining secrecy discussed above all often help to show that the information in question qualifies as a trade secret and deserves trade secret protection. An image of a large Pepsi-Cola sign along a highway in New York City. Figure 5.5, credit, Michael Galpert via Flickr/CC by 20. Learning objectives. After completing this section, you will be able to describe the differences between the misappropriation of a trade secret through improper means and disclosure without consent. Explain how trade secret owners use direct evidence and circumstantial evidence to prove that a misappropriation of trade secrets has occurred. The enforcement provisions of the UTSA allow companies and individuals to protect information that qualifies as a trade secret. The protections allowed for by the UTSA are triggered by the actual or threatened misappropriation of trade secrets. Misappropriation is defined in two ways. 1. Acquisition of a trade secret through improper means, or 2. Disclosure or use of a trade secret without consent. Misappropriation through improper means. The first type of misappropriation under the UTSA is acquisition of a trade secret through improper means. Specifically, the UTSA prohibits the acquisition of a trade secret of another by a person who knows or has reason to know the trade secret was acquired by improper means. Roman 22. Improper means includes theft, bribery, misrepresentation, breach or inducement of a breach of a duty to maintain secrecy, or espionage through electronic or other means. Roman 23. In short, the first type of misappropriation is the mere possession of a trade secret that has been acquired through theft or the breach of a duty to maintain the secrecy of the trade secret. Misappropriation through disclosure. The second type of misappropriation under the UTSA is the disclosure or use of someone else's trade secret without their express or implied consent. Although the statutory definition is somewhat complicated, the UTSA essentially prohibits the disclosure or use of a trade secret that is possessed as a result of theft, breach of a duty to maintain its secrecy, or an accident or mistake on the part of the trade secret owner. Roman 24. In short, the UTSA prohibits the disclosure or use of a trade secret that is possessed as a result of improper means, as defined in the preceding paragraph. The rule of thumb is that if you possess, disclose, or use a trade secret that you know or have reason to know is not intended to be revealed to you, beware. UTSA's definition of misappropriation. The UTSA's definition of misappropriation is rather broad. The protection granted to trade secret owners under the UTSA is further expanded by prohibiting not only the actual, but also the threatened misappropriation of trade secrets. The distinction between these two types of misappropriation is basically one of timing. The UTSA prohibits the actual disclosure of trade secrets and provides remedies for those whose trade secrets have already been misappropriated. A more difficult question arises, however, with respect to a trade secret owner's rights prior to the actual misappropriation of trade secrets. To address a trade secret owner's legitimate concerns that misappropriation may occur in the future, the UTSA prohibits threatened misappropriation. A trade secret owner may assert legal rights subsequent to any actual unauthorized disclosure or use of trade secrets. In such situations, the wrong has already occurred, and the trade secret owner may seek judicial intervention concerning any legal rights that were violated. This is true regardless of whether the misappropriator obtained the secret without the owner's consent, or originally with consent, but later used the secret for the misappropriator's own gain. The burden of proof in an actual misappropriation case is still squarely on the shoulders of the trade secret owner, who is alleging that trade secrets have been misappropriated. This burden of proof requires the trade secret owner to demonstrate that he or she was in possession of knowledge or information that was not generally known and was valuable precisely because it was not generally known, and that the knowledge or information was subject to efforts that were reasonable under the circumstances to maintain its secrecy. Depending on the facts and circumstances of a given case, together with the nature of the intellectual property to be protected, proving the elements necessary to make out a trade secret case can be a challenging undertaking. The best way to establish a foundation for successful prosecution of trade secret misappropriation is to follow closely the provisions of a written trade secret protection plan and take measures to ensure the security of the information as discussed above. Perhaps the most interesting trade secret cases involve the alleged threatened misappropriation of trade secrets. In these cases, the trade secret owner does not contend that their trade secrets have already been compromised, but rather that unless some action is taken to halt the current progress of events, their trade secrets will be misappropriated at some time in the future. Threatened misappropriation cases often arise when a highly skilled or trained employee who has been exposed to a company's trade secrets leaves the company's employ and goes to work for a competitor. On the one hand, the former employer may well have legitimate concerns about possible disclosure of its trade secrets to a competitor. On the other hand, the employee has a right to choose an employer. Consequently, courts are required to balance these competing interests. The result often depends on the legitimacy of the trade secret owner's concerns of misappropriation and the nature of the evidence that is available to substantiate those concerns. When faced with a situation where an employee who has been exposed to trade secrets leaves to work for a new employer, courts typically consider three factors. 1. Whether the former employer and the new employer are competitors. 2. Whether the employee's new position is comparable to the former position. And 3. The efficacy of steps taken by the new employer to prevent the misappropriation of trade secrets. Roman 25. Mere suspicion that another party may have wrongfully disclosed or used one's trade secrets, in and of itself, does not enable the trade secret owner to assert these rights successfully. Courts will not prohibit the wrongful use or disclosure of trade secrets based upon the mere uneasiness or suspicions of the trade secret owner that some misappropriation may occur. Rather, the trade secret owner is required to demonstrate that the concerns of misappropriation are legitimate. In most situations, this means that the trade secret owner will be required to present evidence, either direct or circumstantial, that misappropriation is likely to occur. A trade secret owner may present direct or circumstantial evidence to demonstrate that there is an imminent threatened misappropriation of trade secrets. Direct evidence exists when the trade secret owner can demonstrate that action has already been taken or words have already been spoken that indicate that misappropriation of trade secrets is going to occur. Common examples of direct evidence supporting a trade secret owner's legitimate concerns of threatened misappropriation are statements made by the former employee or the new employer. Former employees might make statements about the relative lack of weight they give to their former employer's confidentiality policies. Similarly, the new employer might make statements about the purpose of hiring the new employee, why other potential employees were rejected, or the nature of the duties the new employee will be required to perform. Based on evidence of such actions or statements, a court is likely to protect trade secrets by enjoining prospectively their wrongful use or disclosure. In the courtroom, however, in most situations, direct evidence concerning the likelihood of misappropriation does not exist. In such cases, a trade secret owner can present circumstantial evidence to demonstrate that the unauthorized use or disclosure of trade secrets is imminently threatened. Circumstantial evidence demonstrating that imminent misappropriation is likely to occur consists of two types. 1. Evidence demonstrating the intent of a party to elicit the wrongful disclosure of the trade secret. And 2. Evidence demonstrating that the wrongful disclosure or use of a trade secret is inevitable regardless of any party's intentions. Evidence demonstrating the intent of the new employer to elicit trade secrets from its new employee takes many forms. Often, a trade secret owner can show that the new employer desires the trade secret and has unsuccessfully attempted to acquire the trade secret information by proper means, either from the trade secret owner, other parties, or independent derivation or reverse engineering. Roman 26. The new employer's intent to misappropriate trade secrets can also be demonstrated by showing that the new employer solicited the trade secret owner's employees and has not made any efforts to solicit employees from the industry in general. Other facts, such as access to a common supplier, access to a former consultant, or failed prior attempts to duplicate technology, can also contribute to a circumstantial showing of intent. Second, in addition to circumstantial evidence demonstrating an intention to elicit improper disclosure of trade secrets, a trade secret owner can show that such disclosure is inevitable by virtue of the particular circumstances of the situation. This showing is most frequently demonstrated by evidence that the work to be performed by the former employee is very similar to the work previously performed for the trade secret owner, and that the former employee will be unable to perform the new job conscientiously without revealing trade secrets previously learned. Although circumstantial evidence is generally not considered as strong as direct evidence, it is clear that courts will issue injunctions prohibiting the misappropriation of trade secrets based solely on circumstantial evidence that indicates such activity is imminently likely to occur. For example, in PepsiCo, Inc. v. Redmond, 54 F3D 1262, the defendant moved from a senior position at PepsiCo to a position at rival Quaker Oats Company, then owner of the Gatorade brand, which is now owned by Pepsi. The court held that it was proper for the district court to conclude that based on the defendant's access to Pepsi's trade secrets, it was inevitable as part of the defendant's new employment that the trade secrets would be relied on. The district court concluded that unless the defendant possessed an uncanny ability to compartmentalize information, he would necessarily make decisions for the new employer by relying on the trade secrets. This was true even though there was no direct evidence that Redmond disclosed any of Pepsi's trade secrets. Act fast. A trade secret owner who suspects that either actual or threatened misappropriation has occurred or is likely to occur must act promptly to enforce their legal rights. Although the statute of limitations under the UTSA is 3 years, courts have the power to deny the relief requested by trade secret owners even when an action has been initiated within the statute of limitations period, if the action has not been initiated reasonably promptly. The UTSA assumes that a trade secret owner who suspects misappropriation will move with reasonable alacrity to protect intellectual property, and recognizes that if such action is not taken, then third parties may materially change their positions in a good faith belief that no trade secret rights have been violated. Under such circumstances, a court may find that the trade secret owner has been estopped from exercising or waive their right to seek protection under the UTSA. These principles essentially allow the court to find that even though the information that a party seeks to protect meets the requirements of a trade secret, equity demands that the information not be protected as a trade secret because protecting it would harm a third party. An image of the Supreme Court building. Figure 5.6. Credit. Joe Ravi via Wikimedia Commons/CC by SA30. Learning objectives. After completing this section, you will be able to describe how injunctions are used to enjoin actual and threatened misappropriations of trade secrets. Explain how remedies are awarded under the Uniform Trade Secrets Act. The UTSA provides a full array of remedies, including statutory damages, injunctive relief, attorney's fees, and exemplary damages. Roman 28. The remedy or remedies will depend on the extent of trade secrets involved, the manner of misappropriation or conversion, and the type of damage sustained by the owner. Injunctive relief. As discussed above, under the UTSA, Injunctive relief is available to enjoin actual, as well as threatened, misappropriation. Injunctive relief allows the owner of a trade secret to obtain a court order prohibiting the actual or threatened misappropriation of a trade secret. The ability to enjoin threatened misappropriation is very important because it enables the owner of the trade secret to prevent public disclosure of the trade secret. Roman 29 injunctive relief may take many forms. The scope of an injunction may vary from a broad prohibition on any use of material found to be a trade secret to a more limited prohibition on the scope of an employee's work with a new employer. XXX, both the scope and subject matter of an injunction vary depending upon the specific facts of the case and the nature of the trade secret in question. The UTSA provides that an injunction shall terminate once the trade secret ceases to exist, but may be continued for a reasonable period of time to extinguish any commercial advantage that otherwise would be derived from the misappropriation. This is especially important where, at the time of the action, the information or knowledge is no longer a trade secret. In such a case, the court may still award the owner injunctive relief that is narrowly crafted to deprive the defendant of the benefit of time saved by improper use of the owner's trade secret. Roman 31. Definition: injunctive relief allows the owner of a trade secret to legally prohibit a former employee, for example, from misappropriating, publicly disclosing, or otherwise profiting from knowledge of the trade secret. Scope: the scope of an injunction varies based on the nature of the potential misappropriator's knowledge of the trade secret, and on the potential competitive advantage that knowledge might grant. Duration and termination: the duration of an injunction is determined based on the amount of time it would take a competitor to reveal the trade secret by proper means. An injunction can be terminated when the trade secret ceases to exist. Permanent injunctions: to determine the appropriate length of time, courts may rely on the opinions experience of experts and competitors. They may impose permanent injunctions or rely on other considerations seen as important by the court. Table 5.2 Injunctive relief. Where the information has not been publicly disclosed, the issue becomes more difficult. The duration of the injunction is often calculated according to the time that would be required for independent development of the information or knowledge that was misappropriated. These Head Start injunctions assume that the information could be properly obtained through reverse engineering or independent development. Roman 32. To determine what length of time is appropriate, courts may rely on the opinions of experts and the experience of other competitors. Roman 33. However, a court may also opt to impose a permanent injunction that can later be modified, or in some circumstance rely on other considerations deemed important by the court. Roman 34. Courts also exhibit broad flexibility in the nature and duration of relief in cases dealing with former employees. When an injunction is issued in these cases, it usually will not be an outright ban on employment. Rather, it will be a more limited injunction for a more limited duration. Roman 35. Most courts are willing to allow continued employment, but will restrict the employee from working with a particular product line or area of the new employer's business. Roman 36. However, if the role the employee will assume would inevitably lead to the disclosure of trade secrets, the employment may be prohibited altogether. Roman 37. Damages awarded. Damages are often awarded in addition to an injunction and are not an exclusive remedy. Roman 38, for example, in Seagate Tech. LLC v. Western Digital Corp. 834 NW2D 555, Min. App. 2013, the Minnesota Court of Appeals affirmed a judgment of $630 million in favor of the plaintiffs against the defendants stemming from a trade secret misappropriation dispute. Under the UTSA, damages are measured by the actual loss caused by the misappropriation as well as any resulting unjust enrichment of the misappropriator. Where the amount of actual loss or unjust enrichment cannot be accurately calculated, the UTSA provides that damages may also be measured by the imposition of a reasonable royalty for the misappropriator's unauthorized disclosure or use of the trade secret. Exemplary or punitive damages may be awarded where the court finds that the misappropriation was willful and malicious. Roman 39, for example, in Mattel, Inc., v. MGA Entomt Inc., 801 F. Sup. 2D 950. C. Decal, 2011. Mattel was found to have engaged in a prolonged practice of encouraging employees to use false pretenses to acquire competitive information from the defendant. As a result of this conduct, the jury awarded, and the court affirmed a verdict of $85 million in exemplary damages. A punitive or exemplary award may not exceed twice the amount of the damage award. However, some states have modified this cap on punitive damages and allow for punitive damages greater than 2 times the amount of actual damages. Roman 41. Case studies. Case description of damages. Seagate Tech, LLC v. Western Digital Corp. In this case, the Minnesota Court of Appeals affirmed a judgment of $630 million in favor of the plaintiff stemming from a trade secret misappropriation. Under the UTSA, damages are measured by the actual loss caused by the misappropriation and any resulting unjust enrichment of the misappropriator. Mattel, Inc. v. MGA Entomt, Inc. In this case, Mattel was found to have encouraged employees to use false pretenses to acquire competitive information from the defendant. As a result of this conduct, $85 million in exemplary damages was awarded. A punitive or exemplary award may not exceed twice the amount of the damage award. Roman 42. However, some states have modified this cap. Roman 43. Table 5. 3. In exceptional circumstances, an injunction may entitle the owner of the trade secret to a royalty for the period of time during which the use of the trade secret was prohibited. For example, the Supreme Court of Georgia has affirmed a trial court's reliance on a seldom-used provision of the UTSA to impose a royalty injunction, instead of an injunction prohibiting the use of the plaintiff's trade secret. Roman 44. A court may also award attorney's fees to a prevailing party in exceptional circumstances. A bad faith claim of misappropriation, a bad faith resistance to a motion to terminate an injunction, or a finding of willful and malicious appropriation are exceptional circumstances in which an award of attorney's fees may be appropriate. However, courts are generally disinclined to award attorney's fees. Roman 45. The attorney fee provision is included to dissuade parties from filing malicious misappropriation actions in bad faith, and considered along with the need for exemplary damages.